legendary group Salt-N-Pepa sues Universal. Let's talk about it. All right, as you can see here, Salt-N-Pepa sue record label to reclaim rights to their recordings, including Push It. Now, I've spoke to you about how several artists or anybody who is an author of a derivative or original work can claim their copyrights back after a certain amount of time. Go back and watch that video here where I talk to you about the Copyright Act of 1976 and Section 203 specifically, where anybody who created some work can get their rights back after a certain amount of years. So here, as you look at the lawsuit here, it says Cheryl James and Sandra Denton, PKA, Salt-N-Pepa versus UMG. They are claiming that after all this time that they have been working with these record labels, hey, it's time for us to get our rights back. So here in the lawsuit, as you can see, that they're suing UMG for declaratory relief. Now, I explained to you what declaratory relief is before. Basically, declaratory relief, they need the judge to determine who owns these rights to this particular property. That's very, very typical when you have a dispute about who owns what. So they go into the judge and say, hey, listen, we want you to make a judicial determination about who owns the rights to the subject authorship of an intellectual property that's contained herein in this case. Now, as you can see here, we go to the lawsuit. It says, since 1986, the defendant UMG Recordings, Inc. has held a copyright grant from the plaintiffs being Salt-N-Pepa. This grant has given UMG the right to exploit the plaintiff's master recordings and retain portions of all monies earned from the plaintiffs from commercial exploitation of their work. Critically, however, Section 203 of the Copyright Act gives the plaintiffs the right to take back their rights in connection with certain sound recordings after a certain amount of time has lapsed since the original grant. In 2002, eager to take full ownership of their art and legacy, plaintiffs sought to exercise their rights under 202 and serve notices upon UMG. So basically, Salt-N-Pepa's like, hey, in 1986, we entered into this agreement, and now 35 years have passed, which would have been 2021 from 1986. So in 2022, hey, they're back up. We can take them back. So they served the notice to UMG and say, hey, listen, you guys have had it all these years. You guys have had the right to exploit our success and all of our work and all of our authorships, all of our music for 35 years. Now we want them back because 35 years have passed according to this federal law. UMG, as it says here, UMG inexplicably has refused to honor the plaintiff's notice of termination. Now, I'm sure UMG's position is like, you can serve it all you want to, but we don't think that you really have a right to these recordings. Now, why would UMG think that? Let's dive deeper here as we look at, why would UMG take this position? Because if somebody is showing you that, hey, we want our work back. I mean, we saw Salt-N-Pepa do it, but UMG said, no, we don't think you are in a position to do that. And why did they do that? But in May 15th, 1986, James and Denton, acting together as Salt-N-Pepa, entered into a production agreement with Herb Azor's production company called Noise in the Attic Production. That was in 1986. Here it says, in 1986, the Noise in the Attic production agreement also included grant of rights to Salt-N-Pepa sound recording. And they go on to talk about how, that's how it was listed in their 1986 agreement. And also says here, that same day, May 15th, 1986, Salt-N-Pepa's producer, Herb Azor, entered into a distribution agreement with Next Plateau Records called NPR. And so now you see it's starting to get a little bit murky here. Salt-N-Pepa entered into an agreement with Noise in the Attic, and then they entered into a distribution agreement with Next Plateau Record, all in 1986. What does UMG fit into this? So if you look at here, right, after releasing several incredibly popular albums and dozens of critically acclaimed sound recordings, on July 1st, 1992, James and Denton, which is Salt-N-Pepa, and the Noise in the Attic agreement, they entered into another agreement with London Records in 1992. And the 1992 London Agreement was for exclusive recording services from the plaintiffs. And the plaintiffs here again are Salt-N-Pepa. So now Herb Absorb's company, Noise and Attic Production, and Next Plateau Records, they all shift things over to London Records. So from 1986 and 1982, now London Records has now exclusive rights, according to this lawsuit, to all of their recordings. And it says, it is also acknowledged as of July 1st, 1992, all of Next Plateau's record rights of the 1986 Next Plateau Agreement were to be assigned to London Records. And James and Denton approved the assignment and ratified the terms of the 1986 agreement. So James and James and Denton both agreed, said, okay, yes, let's just go over everything, you know, from Noise in the Attic to Next Plateau. We agree in 1982 to let London Records have it. Again, how is this over to UMG? So if you keep looking at the lawsuit here, UMG was served a notice, as you see here, on March 22nd, 2022. They said, hey, you know, we want our stuff back. We're gonna serve you notice. We want our authorship back. And UMG responded it says here on June 27, 2002. UMG sent a letter back to Salt-N-Pepa saying, we are taking the position that the notices of termination were invalid and ineffective. Why? Because in UMG's opinion, the plaintiffs, Salt-N-Pepa, has not made a grant or a transfer of the sound recordings to UMG's predecessors. The predecessors being Noise in the Attic Production, Next Plateau Records, London Records. They said UMG is saying Salt-N-Pepa never actually assigned it to them. Why does UMG think this? Well, let's keep reading. UMG said, actually, in the alternative, what they did was those sound recordings, all those years that Salt-N-Pepa did, those should be considered works made for hire, a term defined in the same Copyright Act. Now, what does that mean? Obviously, you know, if somebody's a work made for hire, they don't own it, right? Because there's some sort of employee-employer relationship, or at least independent contractor relationship. But if you go to the U.S. copyrights page, right, it says here, what is a work made for hire under this law? It says a copyrightable work is made for hire in two situations: when it is created by an employee as part of the employee's regular duties, or when certain types of work is created as a result of an express written agreement between the creator and the party specially ordering or commissioning it. When a work is made for hire, it is the hiring or commissioning party is considered to be the author and the copyright owner. That's UMG's position. UMG said, no, Salt-N-Pepa, you did not sign any rights over. You just works made for hire for Next Plateau Noise in the Attic, Next Plateau Records, and then it went over to the London Agreement. You were just works made for hire. That's UMG's position. UMG's position said they never actually granted over any rights. I'm not sure, but that's what UMG is standing on. And that is very, very interesting. They take this approach, and they wrote this to Salt-N-Pepa. And they further went on to say in the lawsuit, on April 10th, 2025, UMG responded stating, among other things, it continued to dispute the validity and the effectiveness of the notices of termination. UMG further informed the plaintiffs that they were ceasing all U.S. exploitation of the sound recording at the time. And upon information belief, UMG has in fact halted all exploitation of the sound recordings in the United States, thereby effectively demonetizing plaintiff's catalog. And this is interesting because, you know, UMG, who now took over after London Records took over the contracts for Salt-N-Pepa, they're like, since we've been owning it and we've been exploiting it, we've been making money off of it via streaming services, via licensing, via you know, all kinds of things they can do when you own play. They said, we're just gonna take it down and wait till all this is over before we decide to do anything. This is an interesting take. And it says, for all these reasons, Salt-N-Pepa had to initiate this lawsuit and seek relief from the court. And if you look here, it says Salt-N-Pepa, the plaintiffs, desire a judicial determination of their rights and duties and a present declaration that their notice of terminations are valid and that the dates of the termination are effective. See, so now here we are. But what do I always say, right? I always say, listen, before, if you're an artist, if you're an athlete, if you're an entertainer of any kind, before you sign anything, you always have your attorney with you to explain what exactly happened. Right here, as you look right here, I'm not sure if there was an attorney present. There's no mention of an attorney being present in this lawsuit that they have here when they first signed their first record deal with Noise in the Attic Production, and then over to Next Plateau Records, and then subsequently to London Records, who then London Records gave it and signed it over to UMG. I have no idea. There's no lawyer mentioned, but I can tell you when these things happen, you find yourself in situations like these. I don't know who's writing the situation. Obviously, I wasn't there, but I will be watching this because now they're asking the court to say, hey, listen, judge, you decide who's the owner of these rights. If it is indeed Salt-N-Pepa who actually own these recordings and then assign their rights over, and then later on transfer them to UMG, then after a certain amount of time, in 35 years, as we stated earlier, then it should come back to Salt-N-Pepa. UMG's perspective is, not happening. You never owned them. You were just works made for hire. So now they're asking the judge, as you see here in their prayer for relief, as you see here, they're asking the judge to enter a judgment for declaratory relief that our clients, the plaintiffs, actually own these recordings. This is going to be so interesting, but this is a very, very, very important case and important lesson, as Salt-N-Pepa is on their way to be inducted into the Hall of Fame, if they're not in the Hall of Fame already, but they're definitely on their way, or they're already in there. Even a Hall of Fame recording group has these issues, and a lot of these things can be avoided when you have your attorney there. So what say you? What do you think the judge is going to say in this case? You tell me. I would love to hear your thoughts. You think the judge is going to say, nah, Salt-N-Pepa owns these things, right? Salt-N-Pepa, no, they recorded it. We heard all their songs, Push It, Shoop, What a Man, Tramp, etc. We saw them. They didn't do it for works for hire. They did it as the actual owners, and they assigned their ownership over to all those aforementioned record companies. Or do you think the judge is going to say, no, you should have been paying more attention. You did not sign that. You were actually a work made for hire according to the Copyright Act of 1976, of what the definition is. Were those record labels actually like employers, or at least and made Salt-N-Pepa to be works made for hire, independent contractors, or even employees? I don't know. It's going to have to go into discovery, and then they're going to have to go into all the documentation of who said what, who did what, all that matters in the lawsuit, which I'm not privy to because I'm not there. I'm not the lawyer on this case, but you tell me. What do you think the judge is going to say on this? Do you think the judge is going to rule for Salt-N-Pepa, or do you think the judge is going to rule for UMG and let UMG continue to own all of these recordings since 1986 from Salt-N-Pepa? I would love to hear your thoughts. This is a great case, great lesson. We'll stay tuned. We'll keep you abreast. It's your brother, Attorney Jeff. Like, comment, subscribe.